the gaming industry is here to stay and in fact it shall grow exponentially in the years to come.
एक बहुत बड़ा ग्लोबल मार्केट है एनिमेशन, विजुअल इफेक्ट्स, गेमिंग, कॉमिक, इन सभी में रोजगार की अपार संभावनाएं हैं.
Now when we talk of gaming, we have the dichotomy which always comes to mind, a game of chance or a game of skill. Various states in the country have enacted legislations equating gaming with gambling and have imposed complete bans on such gaming activities. The law in this area is rather interesting. Unfortunately, there cannot be a central legislation on the subject unless India is currently the largest gaming market in the world with a user base of almost 570 million gamers and almost over 9.5 billion gaming apps downloaded in the year 2023 alone. Pertinently, India's current smartphone base is about 680 million. Now that means approximately every 8 out of 10 smartphone users in the country are playing games on their smartphones. Gaming industry in India has experienced a staggering 28% compounded annual growth rate between the financial years 2020 and financial years 2023. Whereas during the same period, the gaming market in the United States of America and in China witnessed a 9% and 7% growth respectively. Further, the gaming industry is expected to grow at a huge staggering 33% CAGR in financial year 2027. Now this is certainly going to be the next leg of gaming industry's growth journey in India and a testament to which is the multiple gaming unicorns India has already produced. On the back of this high growth rate, gaming industry has directly and indirectly employed over 100,000 skilled professionals in the year 2023 alone, whereas the sector is expected to create a further 250,000 jobs by the year 2025. Now these numbers tell you a story that the gaming industry is here to stay and in fact it shall grow exponentially in the years to come. The government of the day has also taken steps to encourage investments in the gaming sector by allowing 100% FDI through the automatic route. Further, the central government is setting up a national animation, visual effects, gaming and comic center, the AVGC Center for short. It will be a center of excellence in collaboration with IIT Bombay. Also, states such as Karnataka and Telangana have dedicated state-level specialized units and policies to encourage gaming in their respective jurisdictions. There are multiple task forces set up by the central government and many other state governments to help the sector realize its full potential. Now when we talk of gaming, we have the dichotomy which always comes to mind, a game of chance or a game of skill. The law in this area is rather interesting. The Constitution of India envisages a fundamental right to carry on any occupation, trade or business under Article 19(1)(g). The freedom of trade, commerce and intercourse throughout India is also protected under Article 301 of the Constitution. Human life has its charm and there is no reason why life should not be enjoyed along with all permissible pleasures, including online games. And therefore, any permissible form of gaming is also protected under Article 21 of the Constitution as a facet of right to life itself. These Article 19 and Article 301 rights provided under the Constitution can only be subject to reasonable restrictions under Article 19(6) or under Articles 302 to 305. However, on a contrarian approach, various states in the country have enacted legislations equating gaming with gambling and have imposed complete bans or unreasonable restrictions on such gaming activities. States, that is state legislatures, based on this flawed understanding of games and the gaming industry itself, have enacted prohibitory legislations justifying such laws either under entry 1, that's public order, or entry 34, that's betting and gambling, or entry 62, that is taxation of entertainment and amusements, all under list 2 of the Constitution of India. The states have also taken a stand sometimes that online games are gambling acts and therefore they are res extra commercium and not eligible to protection under Article 19(1)(g). Gambling, of course, is illegal, but if it is a game that involves some skill, then it may be protected by law. But how does one decide whether a game is based on skill or chance? It's often left to the courts to decide whether a game is one based on chance or lot, or whether it is based on skill. The courts have held that a game of skill falls within the protective contours of Article 19(1)(g) of the Constitution, and you have the right to carry on business in such games. Further, courts have also held that state legislatures cannot legislate on games of skill simply by virtue of recurring their power under entry 34 of list 2, which only enables the state legislatures to make law on betting and gambling and not for regulating games of skill. The Supreme Court has repeatedly held that rummy, for example, is a game of skill and not a game of chance. In the celebrated case of Satyanarayana in 1968, and even more in the celebrated case of RMD Chamarbugwala, the Supreme Court, in 2 Constitution bench judgments, laid down the law that forms the core for the present legal framework which surrounds online games in India. A game, the result of which is dependent on skill, even if it contains some chance, is a game of skill, and therefore the test is one of predominance. In another leading case, that is Dr. Lakshmanan versus Tamil Nadu, while dealing with the issue of whether wagering and betting on horse racing would be prohibited under the Madras Gaming Act, held that horse racing is a game of skill, and therefore wagering or betting on horse racing would not fall within the definition of gambling. On the back of rapid penetration of smartphone usage in the country and high-speed internet connectivity across India, the online gaming industry has also grown. Various games which were being played in physical form in the physical world have shifted to online platforms. However, various state legislatures, instead of accepting the reality of the digital world, have attempted to draw a distinction between the same game being played in the physical world as compared to that being played online. It has been their case that the same game in the physical world can remain a game of skill, but once it transcends to the online platform, it becomes a game of chance. And on the basis of this flawed understanding, they have enacted laws which held that online games are games of chance, even when such games continue to be played in the physical world and continue to be denoted as games of skill. Several state legislatures, by way of multiple legislations, banned wagering and betting on such online games of skill simply because they are being played online. The gaming industry thus faces uncertainty in regulatory policy within India, given the differential treatment attributed by various states within their respective jurisdiction on online games of skill. The legal framework on gaming industry in India, in its physical form, is governed by broadly the Indian Contract Act, and additionally by one of the foremost legislations that govern gaming activities in India, that is the Public Gambling Act of 1867. The Public Gambling Act was primarily enacted for punishing public gambling and punishing the keeping of common gaming houses. The Public Gaming Act did not distinguish between physical and online forms of gaming, obviously. However, Section 12 of the PGA explicitly excluded a game of mere skill when played, and therefore the rigors of the law were not applied to games of skill. Under entry 34 of list 2 of the Constitution, state legislatures do have the power to make laws on betting and gambling. State, by way of enactments and creating legal fictions, are constantly trying to regulate the gaming industry in their respective jurisdictions, similar to gambling activities. By virtue of this constitutional arrangement, unfortunately, there cannot be a central legislation on the subject unless the Parliament legislates on the subject by exercising its power under Articles 249 or 250 of the Constitution, or by exercising power conferred under Article 252. Accordingly, with the states in India having been conferred with the exclusive power to enact laws on betting and gambling, unfortunately, many states seem to have intruded into the business of online gaming, mistaking it to be betting and gambling. The Public Gambling Act ceased to be a central legislation such that it was no longer a law applicable to the whole of the territory of India post-independence and in the current regime when multiple states made their own legislations. Many states have passed legislations either adopting the Public Gambling Act, whilst certain states such as Andhra Pradesh, Delhi, Gujarat, Maharashtra, Jammu Kashmir, Meghalaya, Goa, amongst others, have resorted to enacting their own legislations on the subject of betting and gambling. Most states have been careful to make an exception for games of skill in their respective legislations, although some states, including Telangana, Andhra Pradesh, Karnataka and Tamil Nadu, took a completely parochial view and have applied a blanket approach to prohibit all forms of gaming, including games of skill or games of chance when played on an online platform. Fortunately, the courts have struck down many of these legislations as being unconstitutional. Courts are indeed the final arbiter. The courts have had various occasions to decide whether a game is a game of skill or chance. How does a court decide whether a game is one of skill or chance? Here is how courts have defined the term skill, which is the key issue here. The game should involve substantial skills, and skills means presence of skill of a substantial degree, and the success in such game should depend principally upon the superior knowledge, training, attention, experience and adroitness of the player. Courts, while dealing with new legislations promulgated by various states banning online versions of games of skill, have held that a game of skill does not metamorphosize into a game of chance merely because it is played online. And therefore, in order to seek the protection as a game of skill, the legal tests would remain the same for games which are played online or offline. Now, whilst the gaming sector is a booming industry and is here to stay and grow, there are real mental health concerns around gaming and even instances of fraud that need to be seriously looked into. The courts have made it absolutely clear in their rulings that fear-based approach cannot be taken towards the gaming industry. If a gaming company offers a game, whether online or offline, and that fulfills the legal test of being a game of skill, it should be legally allowed to operate its business like any other commercial activity in the country.